My clock shows 6 o'clock, so I will take the liberty of getting this Zoom session started. My name is Vern Hawkins. I'm the Vice Chair of the local Ames chapter NAACP, and I am here tonight on behalf of Edna Clinton, who could not be here and who is chairperson of that branch. I will read Edna's opening comments and then turn the microphone over to Mayor. Okay, so these are Edna's opening comments. Welcome to the third Zoom-based session in a series of sessions brought to you by the Ames chapter of the NAACP. The presentations are titled Taking the Lead 2020, Policing and Justice. I am a resident of Ames and I am president of the Ames NAACP branch. The brutal and senseless killing of George Floyd on May 26, 2020, and many others like him are indications that this country still has much work to do. In the aftermath, it has opened the door for real, critical, courageous, and continuous conversations that lead to produce long-lasting, positive changes. Every community, including Ames, has work to do to ensure we are moving towards equity of treatment and outcomes for all. The NAACP advocates for smarter, results-based criminal justice policies to keep our communities safe, including treatment for addiction and mental health problems, judicial discretion in sentencing, and an end to racial disparities at all levels of the system. I would like to take this opportunity to thank the City of Ames for partnering with the Ames NAACP branch to make this important series available. We are pleased that the city has adopted goals essential to ensuring equitable policing and justice. Those of valuing a diverse, equitable, and inclusive community, and of valuing communication and engagement with the public. As you listen tonight, I encourage you to pause and remember that nothing changes when we don't learn, grow, and share with humility and desire. We also invite you to join us for the final session of the series on Thursday, July 23rd, 2020, at this same time, same place. Now we will hear from Mayor John Haila and then our moderators, Jordan W. Brooks and Keisha Ward. Again, this was the introductory statement from Edna Clinton. Mayor?
Thank you, Vern. Well, on behalf of the City of Ames, I also welcome you to tonight's third of 4 community discussions. And again, I thank President Clinton and Vice President Vern Hawkins for their leadership in the NAACP, for tonight's moderators, Keisha Ward and Jordan Brooks, and the panelists, including Tim Meals and Sean Smith, for participating in this important conversation, and the NAACP for hosting tonight's session. The City of Ames is again honored to co-sponsor tonight's event. As was mentioned, last January, the Ames City Council adopted biennial goals that include addressing issues related to diversity and inclusion in our community. In order to accomplish that, objective, open, frank, and informed community conversations are necessary to identify the issues that exist in Ames. We as Ames residents must be actively engaged in discussions similar to tonight. And I am pleased to report that these have spurred on initial conversations with a number of people, of which I've been party to several conversations. They're working, and I'm just so thrilled that the NAACP joined with the City of Ames in order to put these on. Our community is not perfect. Change starts with each one of us. We must first identify what changes each one of us need to make in our own lives. Then we need to work together to improve our community so every person, regardless of their color, race, creed, sex, national origin, religion, ancestry, disability, sexual orientation or gender identity, or socioeconomic status, feels welcomed and is treated equally in our community. It's my pleasure to turn this over to Keisha and Jordan, and look forward to the conversation this evening.
Hi, everyone. My name is Keisha Ward, a co-moderator for the night. I am the owner and photographer of Ward Creative Studios based out of West Des Moines. I'm also the founder of Veganese, which is a branded community based around promoting a plant-based diet. In addition, I am the assistant director of alumni relations at Drake University.
Welcome, everyone. My name is Jordan Brooks. Pronouns are he, him, his. And I am the artist and lead facilitator for No Self, a creative approach to identity development. And I'm also the director of equity, inclusion, and multicultural student success in the College of Design at Iowa State University. I'm happy to see all of you in attendance here with us this evening as we get ready to get into this panel discussion. To kind of set the stage or the atmosphere a little bit, I have some information that was prepared by the folks from the NAACP that I would like to just kind of share with you all to give you a little bit of background into what we're getting into. So, Black and Latinx folks are overrepresented in the US criminal justice system. Iowa's incarceration rate is 568 people per 100,000 people. That's including folks who are in the prisons, jails, immigration detention, juvenile justice facilities, meaning that it locks up a higher percentage of its people than many wealthy democracies do. Black, Indigenous, and people of color make up the majority of those incarcerated in the state, where they are less than 10% of the population as a whole. While racial disparity in case outcomes is often attributed to law enforcement practices or judicial decision-making, the role of prosecutors is often overlooked. Prosecutors actually have wide discretionary power in case processing decisions, from initial screening, charging, bail, pretrial recommendations, to diversion, plea bargaining, and sentencing. County attorneys are considered the gatekeepers to the criminal justice system. Exercising wide discretion as to how law and justice are enforced, county prosecutors determine charging procedures, bail, recommendations, plea deals, jury selection, file discovery, and sentencing guidance. At each point of discretion, attorneys have the opportunity to either perpetuate racialized practices of mass incarceration, or conversely, to advance equity, opportunity, and justice. I wanted to start with that, again, just to let us know, or to let us kind of really contextualize the situation that we have here. There's a lot of discussion that is around police reform or the abolishment of police, but we also have to recognize that there's an entire judicial system, right? It's not just our officers, but it's also the judges, it's also our lawyers and prosecutors in as well. So as we're looking at correcting, fixing, abolishing, changing our judicial system, right, we have to be able to make sure that we're conscious of all points and holding all folks in this endeavor accountable, right, and having the necessary conversations to think and process through where it is that we need to go. So to get us started off, though, or before we get into the questions, I would like for the two other panelists that we have here to be able to introduce themselves. And then I'll give you a little bit of how we'll approach the questions.
Perfect. So I'm actually going to jump in to start us off. Coming forward, first Story County Attorney Tim Mills. We'd love to hear a little bit about you and what your office does.
Sure. Thanks for inviting me to participate tonight. I think all these topics are important, and it's a very timely discussion at this point that we all participate and we all educate ourselves and make ourselves aware of these issues. I was recently appointed to Story County Attorney's office in February after 20 years in the Story County Attorney's office as a prosecutor. I'm from Iowa. I've lived in Ames for 45 years. I went to Ames High School. I went to Iowa State University, got a bachelor's degree in sociology, and then attended Drake Law School. I didn't start school directly out of college, directly out of high school. I actually worked in manufacturing for 11 years before I went to college, and then the plant closed I worked at, and I worked as a maintenance man at the Gateway Hotel in Ames for 2 years. And at the age of 31, I started school full time, and at the age of 38, graduated from Drake Law School. I wanted to enter public service. That was the goal I had in mind, and working at the Story County Attorney's Office was my goal. I worked at Marshall County Attorney's Office for a few months, and then when an opening came in January of 2000, I started in the Story County Attorney's Office. I've handled a general indictable and felony caseload most of the 20 years I've been there. I was appointed first assistant in 2017. And as I said before, I was appointed by the Board of Supervisors as the Story County Attorney last February. The office is responsible for prosecution of county ordinances and misdemeanor offenses. We have 15 attorneys in the office and 10 support staff.
Thank you. And then Sean, defense attorney Sean Smith, if you could tell us a little bit about yourself and what your office does as well.
Thank you. Again, I'd like to echo Mr. Mills' comments. Thank you for inviting me to this important event. I've been a practicing attorney for about 20 years now. I'm a former prosecutor. I worked in the Webster County's attorney's office as a prosecutor, handling general indictable offenses. I did that for about 2 years, and then I transitioned to Story County for about 2.5 more years, and that was in 2003, 4, and I ended up leaving in 2005. Since then, I've been practicing law in the private sector. The first 10 years of my private practice was heavily criminal defense. The subsequent 5, 6, 7 years have been less criminal defense and more of a balanced practice between federal bankruptcy, some criminal defense, personal injury. And I do a lot of pro bono case dealing with federal civil rights violations as well in the context of prison litigation. And that's pretty much what I've been doing for the past 20 years.
Thank you. Thank you for that, for both of you. Really, thanks for being here, being a part of this discussion. I would like to move into the first question. This question will go to the both of you, but first I'm going to start off with Defense Attorney Smith. This is a two-part question. Just let me know if you need me to repeat anything. In general, how do you and your office interact with the police? When in the criminal justice process, do you interact with them, and in what way?
Thank you for the question. When it comes to criminal cases, from the defense perspective, I guess the first encounter we have with the police is when, at least indirectly with the police, is when a potential client, will call us or engage us to represent them because they've been charged with a criminal offense. It's at that point in time that we are aware of the interactions that the potential client has with the police. We're able to at least get the one side of what happened that would bring the person into our office. And then from that point on starts the whole process. A charge is filed or a complaint is filed by the police, and we'll retrieve that complaint. That complaint will eventually matriculate into a formal charge. And at that point, we start interacting with the police probably in a more in-depth level. Most of our interaction, however, is with the county prosecutors and not the police. However, if we think a case may go to trial, we need to collect some more evidence, we do have the option of interviewing police officers in the form of what we call a deposition at that time. And that's pretty much how our interaction works. I do have a relationship with many of the police officers. So what I can do sometimes is if I need something from them, I can give them a call and I can ask for a piece of evidence, or I can ask if they've heard of something or where are they at in investigation. And generally speaking, they'll respond to my call. If they don't, then I'll go to the prosecutor at times. So.
Thank you for that. County Attorney Mills, same question. In general, how do you and your office interact with the police? And when in the criminal justice process do you interact with them, and in what way?
There's two basic times when we interact with the police. That's pre-charging and after charging. And we do hold trainings for the police, advise them on case law updates, and advise them on investigations. Sometimes we're called in when the police are investigating a case, ask for advice on what evidence needs to be gathered, perhaps what charges should be filed. We have an attorney that's on call 24 hours a day. One of us is on call for law enforcement to call and ask questions. After charging, we communicate with the police. Sometimes we ask them to do follow-up on the investigation if we think something needs to be followed up on. We talk to them about what evidence they have gathered, and we also prepare them for trial and call them as witnesses in trial.
And I would like to jump in there. When I was a prosecutor, thank you, Tim. When I was a prosecutor, we served on certain task force with police officers from time to time. I don't know if they still do that. I'm sure it's a county by county thing, but I remember being on a couple of different task forces with some police officers.
Thank you both.
And an advisory role, let me correct that.
Oh, okay.
So kind of building off of that interaction with police and kind of touched on how they're collecting the information. We want to kind of go ahead and dive into that a little bit further. How specifically do you, and I want to start with our County Attorney Mills, how do you specifically work with, how would you describe the process that you use in order to collect evidence for the cases that you are involved with?
Well, our office we have a limited ability to collect evidence ourselves. We could utilize a county attorney subpoena to subpoena documents, phone records, bank records. We usually do that in conjunction with police investigations when they request us to subpoena bank records, say in an embezzlement case or a fraud case. But mostly we rely on the police officers to gather evidence for us. And then when a case is initiated, we will send a formal request over to the police, a form that we use, asking for what evidence is available, and they send it to us. And from there, it can be distributed to the defense attorney in the discovery process. Sometimes we ask for the police to follow up and gather more evidence in a case. If we learn new information, we'll call officers and ask them to do this for us. We sometimes send out evidence to have it reanalyzed. I know we've done that in a couple of different cases with DNA, but was sent to the state crime lab, and then we sent it to a private lab to have it verified. And we work with defense counsel to provide the evidence that they want to examine in a case.
And just to follow up with that, in a case that's involving a police officer, right, and the possibility of them doing something or committing a crime or doing something wrong, how does that process change, differ, or is it the same in the way in which you go about collecting evidence?
We rely on law enforcement to gather the evidence for us in those cases. Sometimes it's the agency does investigate themselves, but in major cases, of police shootings, in custody deaths, we call in the State Division of Criminal Investigation, and we also have the State Attorney General's office review the case for us. So we do, in cases, have outside agencies come in and review the evidence in cases.
And then if I could turn that question back to Sean as well. Do you interact with police in your collection of evidence, and then what is that process like for you?
Yeah, it's very informal, but by the time I get the case, it's usually the investigation is complete or almost complete. A charge has been made and or an arrest has been made. And by that time, the investigation is usually over. However, there's sometimes, though, where the investigation is not complete and I can call the police officer that was the main investigator on the case and requests some additional evidence. I typically don't get too far that way, but I try to sometimes. But typically when I get the case, the investigation is over. We file our formal request with the prosecutor's office to turn over all evidence. Then they'll get it from the police if they don't have it already. Then they turn it over to us. Sometimes, though, the police will send evidence directly to us, but usually it goes to the prosecutor's office first so that they can review it before it goes to us.
And I guess just to follow up with that with you as well, you kind of mentioned that if there's a need where you're needing maybe more information or anything of that nature, that sometimes there might be a discrepancy or issue with kind of pushing in that way. Could you talk a little bit about what those types of barriers are?
Yeah, technically, you're supposed to go to the prosecutor's office, and you could do it informally, but just by asking or conversing with the prosecutor on the case, or you could do it formally by filing formal motions and that type of thing. Now, I have a couple of relationships with some officers that I sometimes can call and ask them about the status, but most times they still check with the prosecutor before they respond to me directly. And they have various reasons for doing that, and Tim probably can shed some more light on that. But yeah, typically I don't get evidence directly from the police. Usually everything comes from the prosecutor. And that's probably more of a prosecutorial discretion thing than anything else.
Tim, would you mind expanding on that a little bit? Again, like why is that necessary for that process? Just again, so we can make sure ourselves, myself, and our viewers are understanding how that works.
Sure, and defense attorneys are always welcome to have the ability to investigate cases for themselves, but evidence that is gathered by the state falls into two basic categories of mandatory discovery and discretionary discovery. And mandatory discovery includes statements made by the defendant, certain scientific testing that is done in a case, as well as the defendant's criminal history. The discretionary discovery category involves most everything else. And the rules provide that if they request discretionary discovery, then the state has ability to request from the defense certain discovery from them. So when the police, we act as kind of gatekeepers of a lot of the discovery that the law enforcement gathers, but the defense has the ability to investigate outside of that also. And the defense also has the ability to conduct depositions, put police officers under oath pre-trial, ask them what evidence they've gathered and where it is, what it consists of. And so that's pretty much how the system works.
And I may add that Mr. Mills is correct. The defense has the ability to investigate the case. That's more in theory than in practice, because you have to have an investigator. A defense attorney really can't investigate a case himself or herself because they could potentially become a witness and they can't do that. But so they have to hire an investigator. Hire an investigator requires, means to do that, which is funding to do it. And in some cases, you can apply for court funding to hire an investigator. Most cases you can't. In most cases, it's just not accessible to you. So that's also an impediment to independently investigating the case. But Mr. Mills is correct. A defense can investigate a case on their own terms as well.
Thank you. Keisha, if you would like to go.
So this question is for defense attorney Smith. So as a local defense attorney, what are the demographics of the individuals that you represent?
That's a good question. They're very diverse. I would say most of the people I represent, you're speaking about just the criminal cases, I'm assuming, correct? Mm-hmm. Or everyone. I represent a very diverse clientele. Most of my clients are Caucasian. I probably have about 5% to 10% are African American, probably 2 to 3% maybe Asian American, maybe a little higher than that, 5 to 6% maybe Asian American. But most of them are European or white American, and to a lesser extent, 10% and below are people of color.
Does it appear that you're defending fewer or an increasing number of individuals of color?
I would say, it's probably the same. But if you go to some other local defense attorneys, maybe the State Public Defender's Office, they represent a higher percentage of African Americans because they are contracted by the state to represent those who are indigent. They are full-time. Many African Americans and people of color are indigent. So therefore, they represent a higher percentage of African Americans, particularly in criminal defense.
Is this representative also of I guess you'll say the change that may or may not be happening with other attorneys that maybe you've spoken with?
Could you repeat that, please?
So just thinking in that change that you just talked about, a little, if you felt like that you were defending fewer or more individuals of color, do you think that's also reflected with other attorneys that you've had communication with?
Well, I think my representation of people of color has been the same for the most part.
Okay.
Yeah, about 10%. And that's across all practice areas. Because I'm a private lawyer and they have to, and it costs money to hire a lawyer. But I would say those who can't afford a lawyer would be more inclined, at least in criminal defense, to be represented by either a court-appointed attorney or the state public defender, no matter who they are. But I think my representation has stayed the same. It's probably increased to the extent that more and more people of color are hiring me for other things other than criminal defense. It could be, who knows,
Thank you.
You're welcome.
Moving over to County Attorney Mills. Let's move into the issue of overrepresentation of Black, Native American, and Latino people in the Iowa jail and prison system. Can you share what steps your office has taken to address this?
Sure, we're well aware in our office, and it's in the forefront of our minds, especially recently, that there's an overrepresentation in our system of minorities, and it's discussed a lot in our office. Some people in our office some of the attorneys in our office, several of them have taken implicit bias training. The sheriff's office has scheduled implicit bias training next month, and I'm requiring the attorneys in our office and the staff to attend that. We're always working on trying to recognize when that occurs. We have a jury instruction now in Iowa that addresses implicit bias for jurors. And we also have case law that requires the court and the state to try and have a fair cross sample of representative in jury trials now. But when we get our cases, 99.9% of our cases come to us from law enforcement charged. It's rare that we charge directly charge someone ourselves. And so we have to judge each case individually on its own merits, look at that case, the evidence in that case, see if it fits the elements of the crime, the facts fit the elements of the crime, and we prosecute cases as they come to us. As a leader in the office, I'm constantly reminding people that we should not treat people differently based on those characteristics of color or race or background. And so we work pretty hard at trying to be fair and equitable to everybody that is charged in our county.
Is just a question off of that. So you mentioning that your staff going through implicit bias training now, is that something that has occurred in the past? Is this a new element of what you're bringing into your office with this training? Is it mandatory? What would it look like moving forward for your office?
The implicit bias training that people have received in the past has not been through my office. I felt it was necessary that we all attempt to educate ourselves on these issues. This is going to be a mandatory training for people to attend. I think it's an important topic. Certainly, we're all aware of implicit bias because it's constantly in the forefront when we're prosecuting cases. And in the future, I think it's going to become part of our standard training to ensure that people are thinking about these issues and are aware of these issues as they process their cases.
Thank you. Pass it up to Jordan.
So to sticking with you, Attorney Mills, can we go into this decision in the prosecute? Because you said the majority of the cases that come to you, right, that the law enforcement provides them to you all, and then there's, I guess, then the decision as to whether or not you're going to prosecute that case or not. So could you share with us a little bit about how you all go about making that decision whether or not to prosecute?
Well, the first thing is that we have to look at what was charged, and we have to look at the facts of the case and determine whether the facts of the case fit the elements of the crime to go forward. One of the great things about being a prosecutor that attracted me to this type of law was the individual discretion that you have, in that if you don't believe in a case, if you don't think somebody is guilty, you have the discretion to dismiss a case. And I think it's really important is that we use that and dispose of cases and dismiss them if we don't believe in them personally. Other than that, we have to look at, the wishes of the victim in a case as to whether to prosecute it, the seriousness of the offense, the effect that it has on the community, what community expectations there are of us to ensure public safety. And we have to consider how this is going to affect the defendant and what are the chances of a successful outcome of the prosecution, and what kind of outcome do we think would best serve the community in protecting it and for providing rehabilitation for the defendant. So I think there's other factors that we take into play in a decision to prosecute a case or not. Sometimes we get cases in and we think it was charged wrongly, or we think the evidence supports greater charges, and so we may file more charges as new evidence comes to light, or we may dismiss charges as evidence comes to light and as the case progresses.
And I just want to follow up a little bit with that as well. So, in our previous questions, previous statements, we were talking about the difference in the number of people of color, Black, Indigenous folks within the prison system. compared to white Iowans, and then hearing how much individual personal decision making and goes into whether or not to prosecute. I'm curious, how many of those, do you have an idea of how many cases for individuals of color and Black and Indigenous people, when they get to you all's office, to your space, that you decide that this isn't something to prosecute? We don't see that this is going to go any further, in comparison to how many of those cases get turned over for white individuals within Iowa?
No, I don't have a statistical analysis of that. My goal has always been to treat everybody equitably and fairly.
Those types of numbers be something that you would be able to put together?
I would imagine that those statistics might be available. But
is there anyone in your office that gathers that information?
There is not. It's gathered by the court system.
Yeah, if I could jump in here a little bit. Yes, there was a study a couple of years ago here in Iowa. I think it was by the local ACLU office. And what they found, particularly for marijuana arrest and conviction, that people of color, specifically Blacks in Iowa, were almost 4 times more likely on average to be arrested for marijuana and convicted, when all the studies show they use marijuana basically the same rate. So I'm not talking about necessarily one county or another county, but there's definitely a problem out there with the discretionary decisions that are made in the street, the charging decisions, and ultimately the sentencing decisions. And I think what this forum and similar forums like this need to shed light on some of those things, and how we could get beyond some of those types of discretionary things, decisions that are made to the detriment of many African Americans, particularly with drug cases like that.
Thank you, Sean. And if you could actually, you mentioned how you were mentioning the marijuana cases and involvement with those. Can you maybe expand a little bit more on what types of cases you are most often asked to defend? And also, again, thinking about racially and whatnot as well.
Well, when I first started my practice, I was doing all kinds of criminal defense cases. I was doing felony cases, robbery cases, drunk driving cases, alcohol offenses. For the most part now, I do lower level criminal offenses, anything from drunk driving and maybe alcohol offenses and that type of thing, only because I choose to do that now. But I pretty much run the gamut. When I was a prosecutor, I prosecuted all kinds of cases, from Class B felonies all the way down to simple misdemeanors. So I pretty much have handled everything. For the most part now, my criminal defense docket is pretty, it's much smaller. It's pretty much misdemeanor offenses for the most part.
Thank you. So I'm going to address now Defense Attorney Smith. Can you share how you make decisions about recommending acceptance of plea agreements or a recommendation of a plea agreement?
Sure. First thing I do is, before we even get to the plea agreement, I look at the case. I try to ascertain from my investigation or my understanding of the case, the strength of the case. There's so many factors that go into whether or not you want to accept a plea agreement, reject the plea agreement, and try to negotiate more. Is one, based on the evidence, whether or not the evidence would likely convict your client. I hate to say it, based on who your client is, how your client will present in front of a jury, whether or not your client has a criminal background or not, whether or not your client has some ambitions, career ambitions, and how what effect a plea agreement or guilty verdict or conviction will have on your client, how your client will present in front of a jury or a judge. All of these factors go into whether or not I recommend or not recommend a plea agreement. What the risk is, you have to understand with a plea agreement, what you're basically saying is you are evaluating the risk of going to trial and getting convicted and maybe serving some type of punishment based on the risk of pleading guilty and getting a defined punishment, for the most part, a predetermined punishment. And and the greater that risk is, the more likely someone is likely to take a plea agreement. For instance, if the risk of going to trial and losing is 5 years more than taking a plea deal and getting a pretty much, predetermined outcome, it's not always predetermined because the judge has discretion in sentencing. But the greater the risk, the more likely is the client's going to plead guilty. And the strength of the evidence as well. Even the strength of the evidence. I'm not talking about any particular prosecutor or prosecutor's office. Many times when the charges are so intense that the risk of going to trial with a very high charges and getting convicted is too great for many people to take that chance. So all of those factors will weigh on whether or not one pleads guilty or not. And the fact and the strength of the evidence, of course.
So when thinking about that too, what challenges do you face in the process?
Well, many times there's all kinds of challenges. Sometimes I look at a case and it's overcharged. And again, I'm not talking about Story County or any county, but it happens in our country. A case is overcharged for leverage. What that means is a case will be overcharged just to get leverage to kind of compel a plea deal quickly. That's frustrating. Sometimes clients are frustrating because as much as you try to explain the case to them, they want to take a plea deal no matter what, or they don't want to take a plea deal no matter what. Usually they want to take a plea deal when they shouldn't sometimes, and sometimes they don't want to take a plea deal when they should. So all of that is frustrating. All of those factors weigh into whether or not you take a plea deal. And their career, what they plan on doing, their criminal history, their family, potential jail sentence, all of these factors weigh in. And all of it's kind of difficult. The more serious the case, however, the more difficult it is. The more serious the case, the less likely the defense is going to get a ruling in their favor.
And so just to reiterate, your main focus on that question was more of across the country and not specific to the county.
Well, every community is a microcosm of what's happening in the country. So just on a lower scale.
Mm-hmm. Thank you.
You're welcome.
So going into with County Attorney Mills, now similarly, can you share how you make decisions about filing charges and permitting a plea agreement?
Well, as I said before, when it comes to filing charges, you have to look at the strength of the case and all those other factors that I spoke of. When it comes to plea agreements, you kind of have to look at those same factors. The seriousness of the offense, the effect it's had on the community, the wishes of the victim, the expectations of the victim and the community as to an outcome in this case. And so the vast majority of cases in Story County, in misdemeanor cases, first-time offenses, those people have no criminal history, end up getting a recommendation for a deferral of judgment. Those are available to most misdemeanor cases, some felony cases, and that allows somebody to complete a period of probation and then there's no conviction entered on their record. So those are some of the things we look at. One of the big factors is protection from the community and how we fashion a sentence that does that. And rehabilitating the defendant, that's the best way to do it. In my mind, if somebody commits a very serious offense, like murder, certain robberies, I think the community has an expectation that we're going to protect them from further offenses by somebody who does that. Recently, we started a pre-arrest diversion program in Story County. We had close to a $500,000 grant from the Department of Justice. The idea is that people with substance abuse issues, drug addiction, mental health issues be diverted before entering the criminal justice system to a program where they have a program coordinator who assists them in finding appropriate treatment for them, directing them towards housing solutions, and setting those things up for them.
Thank you. Before moving to my next question, because it's going to shift us a little bit, I am curious if you could speak to what District or Defense Attorney Smith was speaking about with the overcharging and sometimes seeing cases with overcharges. Could you talk with us a little bit about how then those decisions kind of get made and why it might appear to a defense attorney that these are overcharges, but your office sees them as what's necessary for the case?
Well, in any case that we charge, all the charges have to be reviewed and approved by a judge. From the time that a charge is filed in a complaint and affidavit, a judge has to look at that complaint and affidavit, look at the affidavit portion of it, determine whether or not there's probable cause for the charges that are charged. Subsequent to that, in indictable offenses, which are offenses other than simple misdemeanor cases, we have to file a formal charging document called the trial information. That's done in lieu of a preliminary hearing before a judge in almost all cases in Story County. We have to list out what charges there are, and we have to provide minutes of testimony supporting those charges. So the charges that we do file all have to be reviewed and approved by a judge. We don't necessarily in Story County charge the charges that are filed by police officers. Sometimes we do lower them. Sometimes theft cases that are charged, we lower those to misdemeanor cases. Sometimes burglary cases are charged and we lower them to even simple misdemeanor cases. So I guess we try not to do overcharging in our office. I hope that doesn't happen. I think it probably is a problem if you get somebody in and I've seen in the past prosecutors that have charged in drug cases every single charge they could possibly charge because there's such a wide variety of charges. That's not our goal here in Story County to do those kind of things.
And if I could jump in there, and I definitely wasn't speaking about Story County. I've worked in Story County for the better part of 17 years, but it does happen in Iowa. I've experienced it myself, and I've practiced criminal law in about 8 or 9 counties for a good 10 years. And it does happen, but like Mr. Mills said, if that occurs, they try to nip that in the bud. But what Mr. Mills is saying is correct. In theory, it's correct. Judges will review charges before they're formally filed. But I think in the 17 years I've been practicing, I had one judge reject a formal charge. And I said that to say, not that they're not doing their jobs, but the threshold to file a charge, is what we call probable cause to file a charge, is very low compared to what's needed to convict. So most times when a county attorney or prosecutor files a formal charge, what we call a trial information, the judge pretty much approves it for the most part. I mean, I don't want to be cynical here, but like I said, I've seen one not approved in almost 20 years.
Thank you.
I'd like to add recently that I have seen an increasing vigilance by the judges in Story County in reviewing trial informations and complaints and affidavits. And we do get several times recently that I can think of where judges refuse to sign and authorize a complaint and affidavit saying that there was probable cause, and trial informations have been sent back to us saying, this is insufficient for me to find probable cause on it. So I know maybe Sean hasn't experienced that, but I have.
Thank you. We want to go ahead and move along with Jordan. Go ahead with the next question.
So this next question, could you, and this is for County Attorney Mills, again, if you could please describe how your office handles cases of police misconduct. How do you ensure independence, impartiality, and transparency in your investigations of police wrongdoing?
Sure. As I said before, the police are are the ones that collect the evidence for us. But that does not go to say that they do not investigate themselves and charge officers. Since I've been in the office, we've prosecuted a detention officer for sex abuse back in the jail. We've prosecuted another detention officer for assault in the jail. Those were both investigations that were initiated by the Story County Sheriff, and Ames Police Department also, we prosecuted an Ames police officer for theft. On more serious investigations, we do bring in, as I said before, outside agencies in the form of the State Division of a Criminal Investigation, and we do also have the Attorney General's office, who will now investigate every incident of in custody death of someone who's been arrested by police. So we also sometimes, if an officer feels, if we feel like we're too close to an officer, we have the ability to ask another county attorney to handle the case for us and have a special prosecutor assigned to it. So those are the steps we take.
Thank you. I appreciate it. Defense Attorney Smith, then, have you had cases brought to you regarding police misconduct?
Not at the county level. As I said earlier, I'm involved in a few federal civil rights cases where it's typically misconduct by some type of correctional officer. I had one case a couple of years ago. It was against a local sheriff deputy and a city police officer. It was a federal civil rights case. But since then, they've all been correctional officers. Nothing local with any local police.
And so with those experiences, could you kind of share with us about what your experience is like getting the access to the information that you're needing for your defense in those cases?
I would tell you it's a whole new ball game. It's much more difficult in federal court to get access to a lot of evidence in these cases. As you guys know, if you've been following all the news lately, our biggest hurdle in federal court in order to hold police officers or correctional officers accountable is the courts have mechanisms that pretty much protect law enforcement. You've heard the term qualified immunity. That's one of the biggest hurdles we have in holding some type of law enforcement, whether it be correctional staff or a local police officer or a state patrolman or a deputy. It's hard to hold them accountable in civil rights and civil cases because of what the qualified immunity.
Beyond the idea of making it difficult, with this qualified immunity, what positive purpose for that type of law, right, outside of blocking folks from being able to prosecute?
Well, what qualified immunity is basically says that a law enforcement officer can't be put on trial for using excessive force unless the evidence could show or can convince a jury that the officer used excessive force and the officer knew they were violating a clearly established law, which makes it more difficult. So what that means is you have to show, the two-part test, you have to show that the officer used excessive force and that when they were using excessive force, they knew they were violating some clearly established law. And the way the federal courts, the federal judges have interpreted that to mean is you have to show that at the time it was happening, the officer knew that they were violating some law, and there's a case out there where that exact conduct happened. And that makes it almost impossible to really get any type of traction in court to get beyond the qualified immunity.
C.A. Mills, do you have any input on the qualified immunity as to what the purpose of that would be. Because again, for me, just hearing it, it sounds like, again, it's one of those systemic things that's further harming Black, Indigenous, and people of color, or could potentially do that.
Well, I think qualified immunity also means that not necessarily that the officer knew what he was doing, but he should have known, and that other officers, other people in his situation, looking at it objectively, he would know what they were doing was a violation of rights. And the purpose of it is to allow police officers who have to make snap decisions a lot of times under stressful situations, that if they make a mistake through negligence, inadvertence, or if a misunderstanding of the law, unless it was clearly established that they should have known that it was wrong, that they can continue to do their jobs. Otherwise, if you make a mistake as a police officer without qualified immunity, and it applies to other government officials also, you wouldn't be able to function very effectively and make those decisions at critical moments. That's the idea behind the law.
Yeah, I would like to, just to kind of add a little bit more to that. The law basically says excessive force, so it's not any kind of mistake.
Sean, can you hold on? Sean, can
Sure.
you hold on one second? As we're getting to the close of here, and for time's sake, as you're wanting to continue that, I want to allow about just 1 to 2 minutes for each of you to give any final comments or closing remarks. And I'll first start with Defense Attorney Smith.
Thank you, and thank you for having me participate in this panel. I think it's very important. I think over the past few months, we've seen kind of a resurgence of a lot of these issues. But, to me, these issues have been around a long, long time. It's not just pervasive in law enforcement culture. These issues are pervasive in all aspects of society. The criminalization of Black and brown people has been around since pre-emancipation. And I think once we change that narrative from one of Black men in particular being aggressive or criminality, once we change that narrative, then we'll see a lot of our social organizations be able to change the culture so they understand that Black people of color, and brown people aren't violent or aren't criminal. And once we understand that, then we can change the culture, and that will eventually flow down to law enforcement. Because the law enforcement, I think, in the bigger context, still has this us versus them type of group think that says that we're the good guys, you're the bad guys, and that's how we're going to police. And until we change that culture, I think a lot of these issues are going to persist.
Thank you, County Attorney Mills. Any final thoughts? About 60 to 90 seconds.
Sure. I want to thank you guys for inviting me to participate in this tonight. I think these are important discussions to have. I look forward to more discussions on these issues. I'd like to continue to educate myself about these things. I want to ensure that all of our citizens in Story County are treated in a fair and equitable manner. I'm open to new ways of doing that. As I said, we've got our diversion program we're starting up. We'd like to have drug court and mental health court in Story County too. There's been a moratorium on those by the Supreme Court because of funding issues. I think those kind of things are important, and I think we can always do better. And I appreciate you guys inviting me.
So definitely thank you both for your attendance. And then also to everyone who is here and on the call, we do want to thank you for joining us tonight and coming out for this third discussion. I do want to invite you to please express your comments or concerns by visiting the NAACP Ames, Iowa website and clicking the Have Questions or Feedback button. So again, it's the NAACP Ames, Iowa website, and there's I have a question or a feedback button that you could share your comments and concerns. Also, just as a reminder for all of you, July 23rd at 6 p.m., there will be the final conversation with the mayor of Ames and the ISU president. And so please make sure that you come out and join us for that evening's discussion as well. Again, that's July 23rd at 6 p.m. and that will be with the mayor of Ames and ISU president. Thank you all, and wish you a good evening. Good night.
Thanks, Jim. Thanks, Jordan. Thanks, Tim. Thanks, Keisha.
Thank you. Have a good night.
Yep.